And now I would like to invite the third speaker of our second session, who is Mr. Valentinas Knyva. And he's a data protection officer at Vinted Group. So our beloved unicorn Vinted, Lithuanian-based company. So Valentinas is a DPO at Vinted, and he has over 6 experience in data protection field. And before joining Vinted, he also served as external DPO for several companies. So he has a lot of experience gained during this time, and we are really happy that he can share it with us. So Valentinas, the floor is yours.
Hello, thank you, Migla, and the rest of organizers. It's been a great pleasure to join this conference and to be one of the speakers. So today I will talk about just a second, I'll just present my slides. Yeah, so today I'll talk about the cookies and other tracking technologies and the current and upcoming challenges in this field. As you can imagine, Vinted, like any other website and app provider and publisher, is rather related to the cookies and tracking technologies and the advertising matters. So it's quite inseparable from our business. So naturally, it's a topic that also affects us rather strongly. So I would first like to just go through the major timeline of changes in legal environment. So the basis of the current regime of e-privacy is based on the e-privacy directive 2002 and its e-privacy directive amendments of 2009 that included the idea that cookies that are not strictly necessary for the function of a website of providing services would need to be all other cookies need to have a consent, user consent, in order to be placed on their devices. So, and in addition to that, it was transposed in 2011-2013 to the EU member states' national laws. And of course, another big step in this process was the GDPR coming into force in 2018, as it strengthened the requirements regarding the consent, that it must be much more informed in comparison, that in order to be valid. And that was proven as a major factor in October 2019, as the European Court of Justice made a judgment in Line 49 case. I'll talk about it a bit more soon. And of course, as something upcoming is our e-privacy regulation that's also going to change many things and may affect current cookie and privacy requirements quite a lot. First about the European Court of Justice judgment, the Line 49 case. Important rules were issued in this case because it was stressed that users must actively consent to the storage and reactivation of cookies. Just scrolling a website, visiting it, it's not doesn't automatically lead to a given consent in this situation. It must be validly expressed by making actual active choices. So it's a major change in interpretation, because previously in many countries it was deemed normal that the fact that user is using a specific website may be enough for the cookies to be accepted. So it greatly improved the privacy and rights of the users, because we given the actual genuine choice in this regard. In addition to that, e-privacy regulation, the upcoming privacy regulation, is a rather baffling thing in many ways, because the current draft includes things like a way to whitelist certain cookies and their providers in a way to fight the consent fatigue, and a way just to give consent to browser settings to a wider range of cookie providers and just cookie types, instead of just clicking and giving their consent to every single website that we visit. So it kind of strays away from a current trend of just making the user in control of their personal data. So it's quite surprising, and I believe it has been criticized quite heavily by the privacy specialists in that regard. In addition to that, another rather unusual step was an allowance of cookie walls, a partial allowance of cookie walls, because some websites, their website would, according to the current regulation draft, websites would be allowed to use cookie walls as an alternative if we give an alternative, either to give a pay for users to pay for the access, or to consent to cookies. So it's rather interesting choice that certain scenarios would be allowed, would allow cookie walls to be placed on a websites. Text is not yet finalized, so it may receive a lot of changes, just like GDPR text received many changes from its draft version. So it may change a lot yet, so maybe these provisions will change before we finally receive an e-privacy regulation. Another thing that's important is the increasing national requirements, as many countries are now issuing, many data protection authorities across Europe are issuing new guidelines and recommendations on cookies, and this, in the light of the Planet 49 case, and just in general improving the level of consent that's needed to comply with the cookie requirements. And while there are multiple guidelines released in 2019 as well, in Germany, UK, and Spain, I would like to concentrate on the newest ones, and the most important probably is the French Data Protection Authority's guidelines on recommendation on cookies and other tracking technologies. That one thing extends the information to be provided to users to get the informed consent. So in addition to the current situation where it needs to explain the purposes, the data controller, and the possibility to refuse cookies, it also requires users to, data controllers to explain how users can refuse cookies, how can we accept cookies, and what are the consequences of that acceptance or refusal. In addition to that, the possibility of accepting and refusing all cookies and traces should in most cases be accessible on the same screen. So the current practice, common practice, where refusing all cookies only available as a advanced setting on a second level, on the second layer of a cookie banner, according to CNIL, would not be sufficient, as it pushes users to accept all cookies instead of giving them actual choice. And in addition to that, inclusion of just an X on top of a banner to just close it, in their view, is not enough. It would also need to have some explanation what that X actually does, that it actually refuses all cookies instead of, I don't know, just postponing it or interpreting it as accepting all cookies. So additional explanation is required according to the CNIL. And in addition to that, users must also be able to easily change their preferences. So it's not just enough to hide it somewhere deeply in their settings. According to French Data Protection Authority, users must be able to access their preferences easily, as easy as they are accepting or refusing the cookies. So it should be available at all time on every page. And deadline to implement that is the end of March 2021. So it's really coming to a close rather quickly for the companies that do business in France. And it will be a major subject of compliance action during 2021, as announced by CNIL. So we are taking actually now, even currently, active actions to inform those companies that do not comply with this already, and sending them mails, I believe. So it is quite active. We are taking active actions in this context. Italian Data Protection Authority also issued guidelines on cookies and other tracking technologies. They are not yet finalized, but quite similar to CNIL guidelines, but we provide a general ban of cookie walls. So in all cases, cookie walls that prohibit the access of websites are considered to be inappropriate. And in addition to that, but unlike CNIL, we believe that refusal of all cookies by pressing X would be enough. There's no explicit requirement to include additional information on what that close button would do, because I believe it's quite obvious, I guess, for most users. In addition to the legal changes, there's also initiatives in tech sector. So I'll talk about these in detail in the next slide, but both from browser developers and from Apple, there are some seriously strong initiatives to curb the current third-party cookie and tracking situation. So it's while there are some upcoming changes, and there are already some of that already happened. So Firefox in 2019 began blocking third-party tracking cookies by default, while Safari started blocking some third-party cookies, limiting third-party cookies back in 2017, and in 2020 they finally went for blocking all third-party cookies by default. So Safari users already have that enabled by default right now. Google chose a different approach to Chrome, as we believe that the companies and the current situation needs to be slowly changed over time. So we are phasing out third-party cookies and will only block them fully in 2022. So that not yet happened, but it's due to a Chrome massive market share, it will have massive effect on the current ad and third-party tracking markets and personalized market, personalized advertising in general. Aside from that, Apple, with its iOS current iOS updates, the newest updates that will become live this month, introduced the app tracking transparency framework that makes publishers of apps ask for users' permission to track them or access their device advertising identifier that acts as their tracking using universal ID that tracks them across devices. So tracking in this context includes all cases related to targeted advertisement, for example, displaying targeted advertisement based on user data, in addition to sharing the list of data, personal data with third-party advertising networks. So both displaying the advertising and providing data that could be used for advertising, third-party advertising. And in addition to that, using analytic SDKs that repurpose the data for target advertising. For example, it's quite clear that it's talking about the Google Analytics cases, where Google Analytics are both used for analytic purposes and also gather data for clear advertising purposes as well. To describe what challenges these changes lead to, I would like to mention that by blocking cross-site tracking, it inevitably affects websites and web publishers because a huge part of websites and apps are driven by third-party cookies and tracking because as they are needed for advertisements to be shown on those websites and apps. As a result, there's also an issue that advertisers are often stated unwilling to participate in real-time bidding. So to have their ads shown on websites, if the ads is not going to be personalized. So there's an issue that advertisers, as a result, would not really prefer to use to present their ads if they are not going to be tailored for those recipients of those ads. So it's also an issue because, well, publishers of apps and websites are kind of forced into the situation where they need to either collect that data and present the advertisements that's personalized as a result, or we are not going to get relevant ads on the websites, and then as a result, lower the ad revenue. So it's kind of leads to like a rather unhealthy cycle where data needs to be collected in order to satisfy the advertisers. Is it a good situation? I guess not, but there's really not a lot of things to be done in here to avoid that. currently. And blocking of third-party tracking further cements Google's dominant position because its initiatives like Privacy Sandbox, their technological solutions, they all push companies to rely on their advertising tools. And as a result, all companies that do not already have like that position that they need to still gather personal data to be able to track users to present relevant advertising, we are forced to use Google. We are kind of pushed away from by Google. And that may be one of the reasons why Google is not willing to make these changes to Chrome right now and just block all third-party cookies, because it may lead to situations that could show that Google is using its dominant position and just against its competition in that way. So yeah, so it's kind of concerning that Google may be one of the winners in this situation where privacy is trying, where privacy and interest of users are trying being defended. So in addition to that, certain other large tech companies and publishers remain in a better position because we already have that information about the audiences. We don't need to receive that information from some third parties, for example, Facebook, Yahoo, Google, and other publishers currently already own a lot of information about their users and can already make present advertising based on that information quite easily. And to finalize, there are currently all companies are searching for ways for all stakeholders in this situation are trying to find their options, both technological solutions or just radically changing the current practices and just going for something potentially rather old school, like just presenting advertising according to a website that is being visited instead of analyzing the whole history of that user, of their interests, and trying to just come up with some advertising according to that. So yeah, that would be about it.
Thank you very much, Valentinas. It was very interesting to hear your thoughts. I have one question for you when it comes to practices of cookie collection, which most of the companies have. So I believe that, well, in my practice, I believe that most of the companies which collect cookies and which use the cookies very actively, they know that their practices are most likely either in the gray zone or a little bit in the already the red zone already. So what do you think could catalyze the more, what could influence the companies to have a more diligent view towards their use of cookies? I know that some companies usually say that, well, I saw the competitor of mine is still collecting this and this like marketing data with no consent, etc. So this is what I'm going to do because I'm going to be in a worse marketing position or something like that. So. And I wouldn't like to believe that it's only the fines, or some administrative things that could catalyze it. Maybe a good example could influence other companies to keep up and step up in their cookie collection practices. What is your view on that?
Yeah, I believe that while enforcement actions and can do some good in that regard, and it may force companies to change, I guess the whole cultural shift is kind of needed, because as long as it's more profitable and more useful to just gather personal data in questionable ways for marketing, it will always be that companies will not be willing to make those changes sometimes. We'll try to find some ways to go around it and find some other means to gather that data if something becomes legal. In addition to that, I guess it really depends on the users, because the more and more privacy, people are conscious about their privacy, and they understand that they wouldn't like to be tracked. We find it kind of creepy that personal data is still collected without their consent, without their control. So I guess it both depends on the cultural shift in the whole infrastructure of advertising, and in addition to that, a cultural shift of the users that may not be as tolerant to these practices as they maybe currently are. So yeah.
Yeah, I believe we are really living in the times of this cultural shift towards better understanding what data protection is. So I hope that your wish also comes true. So thank you very much, Valentinas.